Welcome to the Retzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Ericka Adler, shareholder and leader of the healthcare practice at Retzel and Andrus. And today I'm joined by Christina Kuta, who's part of our healthcare practice. And we're going to be talking about what practices need to do in order to prepare to sell from a diligence standpoint. Christina and I have been working on a lot of transactions lately and handling a lot of diligence. And one of the biggest issues we come across is how ill-prepared practices are from a diligence standpoint in order to do a transaction. And this has to do not only with not being able to find documents, but also being non-compliant in a variety of ways, which can sometimes affect whether a transaction will go through or not, and other times can affect the terms or structure of the deal. So, Christina, thanks as always for being here.
Hi.
Let's start with why practices need to think about getting their due diligence in order before they sell. What are your thoughts on that?
So yeah, it's super important. And the reason it's important is a lot of people think, well, I'm going to sell my practice, so it's going to be easy. I'm going to sign some papers and the other side's going to give me a check and then I'm going to hand them over my practice. And I guess from the 50,000-foot view, that's sort of what happens. But underneath that all, there's a lot of work. And that work generally involves a lot of due diligence. And you mentioned sort of particularly, private equity investors are being involved a lot more in healthcare sales and healthcare purchases. And they tend to take a very scorch the earth sort of compliance to diligence, which means they're going to look at everything. And it's very smart for you in advance to have sort of pre-looked at certain regulatory issues and compliance issues to sort of correct things prior to going on the market and putting a practice up for sale. And to, if you have items that you haven't done or haven't completed, to have those taken care of. And it really can help with the sale. First of all, if you've done a great compliance review, you can be a lot more attractive to buyers because it shows them that they're more apt to be buying what we call a clean practice with minimal regulatory or compliance issues. That also could even increase the value of your practice. Ericka and I have seen multiple times practices not be prepared for diligence. There's a lot of issues that are discovered in diligence, and the response that often is to offer a reduced purchase price. So it really can impact price as well. Also, it's a great time to just identify issues that might be incorrect for the purposes of sale, but also what if the sale doesn't go through? What if it takes longer to get a buyer? What if a buyer comes and for some reason the buyer pulls out? You at least have already taken steps to make your practice compliant as you're moving forward, which you need to do to operate anyway. So there's really a number of all positive reasons to prepare your practice and do the reviews we're going to talk about today prior to finding a buyer.
Right. And one of the things I'll mention is that the legal fees spent on diligence and working with regulatory counsel could be reduced if you're ready ahead of time and can answer questions properly. Sometimes when we get involved with deals, they restructure the deal based on what they find in diligence, which again, spend more on legal fees. And other times, if the legal discoveries are of the type that require disclosure to the government, again, not only are you talking about legal fees that you incur in order to make that happen, but we could also be talking about some of the purchase price being set aside in escrow, which means less for the seller as well. So lots of reasons to do this. So we can't possibly in this one episode talk about all the many compliance issues that we come across. So we thought we would touch upon some of the major ones that we know our practices struggle with. And the very first one is billing. So in a general sense, we recommend practices always have regular compliance audits done. And we can certainly talk about that with any practice that's listening to this. But what I want to talk about are some of the most common billing issues that come up when you're in the diligence. So, Christina, what are the ones you see the most?
So one of the most major billing issues that we see is failure to correctly document what we call incident to billing. So incident to billing is where you have a mid-level provider, so a physician assistant, let's say, or a nurse practitioner, that is actually providing services, but they're being billed as if they were provided by a supervising physician. It's a creature of Medicare, but there are commercial insurances that follow an incident to billing guidelines as well. But I mean, the basic requirements are patient comes in, they're seen first by a physician. That physician establishes a plan of care for whatever concern or issue the patient has. And then if a patient is seen by a mid-level provider after that, related to that specific plan of care and that specific issue, and the supervising physician is on site, meaning in the office, when the mid-level is providing a service, generally it can be billed incident to, and that way it's paid at 100% of the physician rate, even though it was provided by a mid-level. If a mid-level bills directly for the service, is enrolled in Medicare and bills directly, for example, it's paid about 85%. So you get sort of a lower payment. So there's an advantage to billing incident to. You get a higher payment. The issue is all the things I talked about. If a patient comes in for pain in their foot and the doctor identifies, let's say, a stress fracture, and that patient comes back and sees a PA for follow up for that stress fracture, and then they want to see a PA because they have what they think is the flu, they see the PA for the flu, the doctor hasn't seen the patient for the flu. So that flu appointment can't be billed incident to because it's not something for which the doctor has already established the plan of care. And unfortunately, I think a lot of practices don't understand those rules, or I think practices grow and there's not great communication always between the billers and the practice. So the billers just think, well, everything for, this nurse practitioner, we always bill incident to. Well, not necessarily. So a lot of times we see practices that are not billed incident to correctly or have not properly documented correct billing. And that's a huge issue because it's often for Medicare, which is a government payer. So now we have a government liability issue. And when you're selling, buyers don't love to see that because they're worried about potential future liability related to those billing issues.
Right. And this is exactly the kind of situation where even if they're just buying your assets and they're not buying stock or anything like that, they may still want it to be reported to the government, corrected, and they may, consider reduction in purchase price. It also can impact the numbers that were reported. I think it's important for people to know that you can have, PAs and nurse practitioners who have their own billing number, and you can switch between billing incident to and having them bill independently. You just have to kind of stay on top of doing it right. So, there's a lot of issues wrapped up in that. A second issue that kind of relates to this, I think, is credentialing, and people thinking, even though we've been talking about this for years, that until somebody is credentialed, you can just bill them under somebody else's number. And a lot of doctors will swear that they were told that that's an okay solution. What are your thoughts on that issue?
It is not an okay solution. There is very rarely a situation where that's appropriate and proper. You've got a new doctor coming into the practice, Dr. Smith. Dr. Smith's going to take time to ramp up credentialing with commercial insurers, with Medicare, Medicaid. It is not okay for Dr. Smith to provide a bunch of services and bill those under Dr. Jones's billing number because, well, Dr. Smith wasn't credentialed yet. Then Dr. Smith should be seeing only out-of-network patients or patients for whatever reason aren't being charged, like maybe pursuant to a charity care policy or something that a practice has, appropriately in place until Dr. Smith is credentialed. I mean, we see this a lot. There are a lot of billers out there that tell practices this is okay. If you have a biller that tells you it's okay to do this universally, you should get a new biller because it is not okay. And it is a problem because now you've filed a bunch of claims that are essentially false claims. And, filing false claims to commercial insurers is one thing, problematic, but filing false claims to the government is a whole bigger issue. So, you want to look for those issues. And that's why having an outside independent auditor, and I stress, and Eric and I always stress this, independent auditor. You have a biller. Your biller's billing a certain way because your biller thinks in most instances that's the proper way to do it, right? They only know what they know. If they're doing something wrong, they don't know it. They're likely not going to self-correct because they're not aware of the problem. You've got to have an independent third party come in and take a look at a subset of claims Modifiers is another issue, inappropriate use of modifiers, incorrect use of modifiers. Those are things too that you need to really focus on and look at as important when you're doing any kind of billing audit.
Okay, yeah. And one other thing tied to that is that if you're going to do this audit, make sure you do it through legal counsel. So whatever they find out you've done wrong is at least, protected by attorney-client privilege. And, just hopefully you're using an auditor that is well versed enough that would recommend that to you as well. So, all right. So we could go on and on about billing, but I want to touch upon a couple of other things that come up when we do due diligence. One of them will be they will always ask for a copy of a compliance plan. And most practices, small ones, will say, "What's that?" Right? What are your thoughts on what practices need to do in terms of having a compliance plan?
So yeah, practices need to have a compliance plan. And compliance plans don't have to be super expensive, pardon me, extensive based on the size of the practice. Compliance plan for a huge 500 physician practice is obviously going to be more robust than maybe for a solo or a small provider practice. So you just need to have something that addresses specific compliance issues for your practice. And generally it's billing, it's regulatory issues, it's how you handle, certain issues in your practice, like maybe sexual harassment or, employee discipline. There actually is a small compliance plan sort of outline that the government put out of 7 key factors they believe should be in a compliance plan. And it was specifically identified for smaller practices. So it's a very helpful resource actually to look to that. But you have to have something in place. And not only does it need to be in place, you have to be abiding by it, and your employees need to be aware of it and should sign off on something or have some sort of acknowledgement that they know there's a compliance plan, they know where to find it, and they're going to comply with it. If you have one in your desk for 10 years that's dusty and you just pull it out and say, here it is, but nothing in it you're actually doing and nobody you work with even knows about it, it's essentially like you just don't have a compliance plan.
Right. And a lot of compliance plans also, just to be clear, touch on issues of regulatory healthcare, right? So I want to dive into a couple of those. One of them would be having to do with fraud, right? Healthcare fraud. So, it's supposed to encourage employees to help employers, address areas of concern that they may spot. And so when you're buyer's counsel saying we want to see this compliance plan, they want to see kind of what you're in there, what you put in there, and whether you've been following it. And so there's little sub issues that I want to kind of address. So one of the first ones might be marketing, right? What kind of marketing is the practice doing? And the reason that buyers will ask about this is because it directly ties into the anti-kickback statute, right? Is your marketing staff or are your physician giving gifts? Paying for referrals in any way, et cetera. So that's really what they're asking for when they're talking about this as a compliance topic. Christine, I know you and I recently did a transaction where, we talked about marketing. In fact, you'll be on the phone with the buyer's counsel and the seller and the seller's counsel, and they'll run through, did you ever do this? Did you ever do that? And there were a couple of things that we only found out about our client was on the phone. And this is certainly not the first time. And it's because in what people can do in regular business is different than what they can do in healthcare. So give us some examples of some marketing issues that we see.
Sure. We see a lot. And if I had a quarter for every time I heard a client say, you can't do that, I could probably retire early. Because what'll happen is the marketers are being paid a percentage of income. So it'll be, go out marketer, provide marketing services. And for every patient that comes to us, we'll give you 50% of what we collected, or we'll give you X dollars per patient. That is not allowed, disfavored, and shouldn't be done. Marketing fees should not be tied to business generated. And the response to that always is, but you can't pay a commission to a marketer. Well, you can-ish, but not in that way. And healthcare business is different than other businesses. If you're a shoe salesman, you can be paid 30% of all the profits from the shoes that you sell. That can't be the way it's done in healthcare. Just not. So that's an important thing to consider. Marketing tactics. Ericka hit on this a little bit. Don't give gifts to people. I've had, practices that give actual cash to like nursing homes to call them in to service patients in nursing homes that need healthcare. Absolutely not legal. The grayer areas, you bring a referral source lunch twice a week. You throw them a big holiday party that costs $2,000. Those things aren't really proper either. I mean, there are limits on gifts that you can give. I think it's 15 right now. It's $15 for kickback purposes. It's $15 per gift, up to $75 an annual aggregate. You want to send a box of chocolates at Christmas time, holiday time. That's okay. You want to bring coffees to the front desk once a quarter. That's probably okay. A box of donuts. But taking people out to dinner, taking them to I'm a Cubs fan, so taking them to a Cubs game and a suite, that's super expensive. I mean, these are things you have to really consider. And a lot of practices do it and don't realize that it's a problem because everybody else does it. Well, everybody else outside of healthcare can do it, but healthcare is a very highly regulated area.
Some of these rules are very much geared to federal dollars. So practices that are cash based may have a little bit more flexibility, although, Christina, some of the percentage you mentioned are actually state law, not federal law. So there's a couple of different things to keep in mind. And the other thing is that there are very specific guidelines under Stark and anti-kickback about what can and can't be done. And I know 10 years ago, a lot of our practices used to have on the fridge a list of who was bringing lunch that day. It was so widespread, especially the pharmaceutical industry in particular. It was such a widespread practice. Today, we see a lot less of it, but that doesn't mean that practices aren't doing more than they're legally allowed. So you need to know what are the limits under, federal law, Stark anti-kickback, and are you exceeding them? And then this compliance plan in particular that we're talking about here would be educating your staff about what they can do. That's the whole purpose of a plan, is to say, these are our policies, follow them, right? And then the practice, of course, has to enforce them. So if you're on a call with buyer's counsel and they're hearing that you did all these things, in their mind, they're thinking, what is the risk of doing business and acquiring this practice when they have potentially blatantly violated federal and state law? So it's a big red flag, right?
Yeah, very important. And to also just add a little bit too, we talked about the kickback law with the federal dollars, but a lot of states have kickback laws related to commercial insurers. There's ECRA law. ECRA is related to kickbacks and recovery issues, but it was very broadly written, so it relates to kickbacks related to lab services, and that is for any payer, whether they're federal or not. So if you're true cash only, maybe you can get away with some of these things, although I still don't think it's a great idea. But if you have one payer that pays you that's outside of you and the patient's arrangement, it's going to be problematic.
Right. So there's so much we could say about the anti-kickback statute, but that is one of the key things that you're really going to cover in your compliance plan. Hi, everyone. We're going to talk a little bit more about Stark and some other diligence matters that you need to think of as we pick up this topic at our next podcast. Thanks for joining us on the Health Law Hotspot. And please join us next time when we continue this great discussion. Thanks so much.
The Retzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Retzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Retzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.